affected by a judicial decision, that person ought to be heard, with or without the rule. And so the issue of the rule coming in aid with the greatest respect does not even arise. We are raising a fundamental question that relates to the rules of natural justice. It cannot be said that Order 4 or any other rule, if not complied with, satisfy the requirement of hearing. It cannot be the case, with the greatest respect. 2. Yes, proceed. In addition, my Lord, even without Order 4, my Lord, it is even in the interest of justice and fairness, which this court is supposed to uphold, that a person who will be affected must be heard. And in this case, with the greatest respect, that was flatly ignored. And so, my Lord, the point we are making, that decision or the orders founded on that refusal to hear the applicant, even when they themselves came to the court. My Lord, should not, with the greatest respect, be endorsed, because the precedent will be dangerous as far as the rule of law is concerned. My Lord, 2.
In what sense will the precedent be dangerous?
No, my Lord, the point I'm making is where a party, in fact, maybe let me put it this way, 2 parties can actually collude and overreach a person who will be affected. And that precedent is dangerous. And in this specific case, when the application for mandamus was moved, the judge asked counsel for the respondent, are you opposed? He says, no, I'm not opposed.
Does that make it?
No, I'm not saying so. My Lord, I will say so. My Lord, I will say so. But the point is that if this is allowed, that possibility is so grievous and present. And that is why this court must deprecate, with the greatest respect, that conduct.
Also pay attention to the affidavits in opposition,
yes,
and then the statement of case in opposition.
Very well.
Address them.
My Lord, with the greatest respect, and I want to draw this court's attention to judicial review application. Why judicial review application? My Lords, exhibit attached to our judicial review. My Lord, we attach exhibits, that's the Republic versus High Court, Electoral Commission Respondent, National Democratic Congress. My Lord, it's in the supplement. Yes, so my Lord, I'll be very specific. SBT. I have a supplement.
Is it a problem you have created for us? Some of the exhibits, I have them as B, and my other I have it as A or C. Is the problem you have created for us?
My Lord, I'm sorry. I'm sorry about that.
Unlike the other parties who have actually flagged.
My Lord, that should be exhibit D in our supplement. Is the application for judicial review by the NDC.
Yes, you make the point, and let's see if it will help us locate the exhibit.
Okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. But they were before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even filed ours on the 16th. On the 16th of December. This mandamus application was filed on the 17th. But my Lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same.
Oh, okay.
Was it pending in that court or it was right before him?
My Lord, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. Now, my Lord, these are declarations with video evidence. So consider my application first. He ignored it.
I lost respect.
Yes,
you see, some of the facts being heard on this court are indeed erroneous. They are erroneous. And I think it's fair that I put them in context. Okay. The process he found.
Counsel, you can read.
No, just hold on.
Please. What he found was not before the judge. It was not before the judge.
No, it may not be on that docket.
Was listed.
It may not be on that docket, but it may be in a separate docket.
No, he came to court holding the documents.
No, we're talking about the second application. Or the first application, the one they filed on 6.
The one they filed.
The first application. Okay. So, Mr. Tamaklo,
yes.
Continue.
So, my Lord, at the time, my Lord considered he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it and started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared during the mandamus. He knew that that would definitely affect their rights. My Lord, on the grounds of bias, my Lord, the point we make here is that at the time, with respect, my Lord was considering the mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he's done hearing, our application for judicial review would have become moot. Manifest bias. Malak 2. The mandamus application, in one breath, my Lord says our gender on page 2. Offense under 20 rule 14 of CI 47. However, my lords, the mandamus application that was granted, with respect, had no statement of case attached. So in one breath, my lord was holding us to the strict compliance of the rule, but in the other breath, waive it for the interested party. My lord, without the statement of case, the court's jurisdiction for the mandamus was not properly even invoked. And so the orders founded on it were definitely done in excess of the court's powers or its jurisdiction. We submit.
What is your authority for saying that?
Mark 65 rule 6. 2.
It says what?
6.2. The court may, on the hearing of an application for judicial review, then 2, within 14 days after the filing of the notice of application, the applicant shall file such copies of the applicant's statement of case. And my lords, this court, in the case of and Nitete Ahinkwa II and Thomas Okai, civil appeal number J4 2009, dated 29 February 2010. His Lordship Justice Badegbe had this to say, that when J4/20/2009, it was dated 29 April 2010. It says, quote, where the rules of court prescribe a particular mode of seeking relief, then a failure to initiate the proceeding for relief in accordance with the prescribed mode is not only an irregularity, but raises an issue that goes to jurisdiction. Now, in excess of jurisdiction, specific. In the case of Francis Owusu-Mensah and another, versus National Board for Professional and Technical Examination, civil appeal number J4/57/2017, dated 1st May 2018. It was held.
Council 57 or 67?
57. Eniegwa JSC, as it then was, has this to say: a court may have jurisdiction to entertain a cause or matter, but the procedure invoking its jurisdiction may deny the court's jurisdiction. In this case, the court, the High Court, has the jurisdiction to entertain a mandamus application. But the rule says, at the hearing, a statement of case must be attached to the application. That is how the court jurisdiction is invoked.
Mr. Tamaklu,
My Lord.
even in this court, your colleague raised a fundamental issue, preliminary objection, which we have waived.
Oh, my Lord, I take it that you are willing to waive this one.
And we said that, look,
No, my Lord, when you waived, it was on record as having waived it.
so it's
In this case, my Lord, the ruling of my Lord is before you. The court never said they are waiving that non-compliance. My Lord, the court never said that. It is a different thing if the court, in exercising its powers, gave an indication on record that it is waiving that non-compliance. That was not done. My Lord, it's a court of record.
Yes.
My Lord,
In fact, does it matter to you that the other side did not file an affidavit in opposition? Does it matter to you
yes, my Lord.
that the EC before the High Court was not opposed to the application?
My Lord,
Therefore, the waiver even started with the EC.
No, my Lord, the waiver is not one that the party should raise, with the greatest respect. It's not one that requires that a party should raise an objection to the non-compliance.
The party may raise it.
Yes, I'm saying that without that, this court is required to consider it.
Yes.
Yes, my Lord. It does not even arrive. But my Lord said we had offended the rule.
Okay.
2. Now, a clear 3 year. That one we attach a it's a certificate attached. But he says he is applying the ruling mutatis mutandis. I want to bring to your attention the decision of this court in the report versus High Court Bogatanga. In 2001, Supreme Court of Ghana law 63, sorry. The Supreme Court to quash the orders of the High Court. Hawa Yakubu had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said to be, and all the orders High Court in Bolga were quashed. And the resulting effect that all the consequential orders having been founded, this the first filed by the Electoral Commission the position made is that because
proceed.
Because the applicants were not parties at the time the application was heard, they deserve no rights, or there's no issue of breach of the rules of natural justice. My Lord, that is completely far-fetched. Because the application for judicial review, which had the video recordings of those declarations, was duly served on the respondent. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. Or if he only stood up and said he's opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. There is a new. And that is exactly the decision of the Supreme Court in ex parte Hawa Yakubu. My Lord, at this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission, deposed to by Mr. Samuel Tete, be expunged from the records of this court.
Why?
My Lord, these are matters that are not within his personal knowledge. He is not the returning officer of any of the constituencies named.
I think he preceded his affidavit by stating that within his knowledge and information, didn't he?
My Lord, the point we are making is that, with the greatest respect, my Lord,
yes.
One, he does not attach any official record or official document to the deposition, or a police report by any of the returning officers detailing the so-called
so
of fraud.
that weakens the weight.
Very well.
I don't think we...
No, my Lord, I just want to bring it to us that those depositions should not be responded to.
Oh, no, we said that, the man stated that to his information. If he thinks that it doesn't actually establish a fact, that is a different matter. But you can't, you don't say we should expunge it.
My Lord, the respondents say they had already done the collation. And so what is the point, you considering our application? My Lord, the morning of that Friday, with the greatest respect, I had appeared at General Jurisdiction 6 with my learned senior Justin Amenuvo and Gary Limaku, where there was a pending injunction application against the Electoral Commission. That my Lord,
my Lord, so far, various allegations have been made in this court in the course of his submissions, which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
No, counsel. If he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the needful. So anytime he's going beyond his affidavit, draw our attention. Yes, counsel. We have a.
Please restrict yourself to your affidavit and let's go on.
Yeah.
yes, my Lord. So, my Lord, no, my Lord. So our response is that at all material time, there was a pending injunction application that we had all appeared before the judge and gave us 2 days.
My Lord, this is not before the court.
Okay. So you haven't deposed. You haven't deposed.
It is not in your affidavit.
You haven't deposed to it. So let's go on to another point.
My Lord.
You were addressing us on what you said is the argument that the declaration has been done already. So address.
My Lord, our quick response is that, in fact, in the Hawa Yakubu decision, orders were made, and those orders were even complied with. But when it was brought to the attention of the Supreme Court that there was a fundamental breach of the rules of natural justice, the decision and all the consequential orders founded on it were all set aside. My Lord, it is on this basis that we make this prayer. Yeah, I'm the most. So, my Lord, it's on this basis that we invite this honorable court we urge on this honorable court to quash the orders of the High Court General Jurisdiction 13, my Lord, maybe just a quick point. In paragraph, my Lord, with respect, in paragraph 10 of the 2nd to 7th interested party affidavit in opposition, particularly paragraph 10, it is deposed to the fact that our agenda was heard.
Yeah, that's their case.
That our agenda was heard and dismissed. Yes. My Lord, with the greatest respect, the agenda application was treated in a very cavalier manner. Cavalier. In fact, it was not moved.
The problem I'm complaining about, what you are alleging, my Lord, is not captured in affidavit.
Is that paragraph what?
To the paragraph where you said the agenda was heard. Agenda which was not on the docket, how can it be heard?
No, I think their case is that the court gave you a hearing.
Yeah, that's what I'm responding to. And I'm saying that we were not heard.
So it's different from saying that the
very well. We were not heard. And my Lord, nowhere in my Lord's ruling did he say, with respect, that he heard our agenda and dismissed it? Nowhere. In fact, he himself said he will not allow the agenda to affect the quick hearing of the application. How can that same agenda be deemed to have been heard?
No, he said he gave you a hearing on the application.
Yes, my lord, and that is why we are.
So it's not a joiner. He had before him an application for mandamus. And there are cases that when you appeared, he heard you on the application for mandamus.
No, my lord.
No, I'm trying to get you to understand their case. You are misrepresenting their case.
Very well. So, my lord, the point we are making is that we were never heard on the application for mandamus. Because first we were praying that we will first be joined, then we'll be heard.
Mr. Tomekulu, I'm reading something from Nana Akua Owusu, a 3 years exhibit. I think it's the first one.
My lord, 1 minute.
Yes, I have it as A series. The one in respect of Nana Akua Owusu Afriye.
My lord, I want to just locate my.
I believe it's yours as a B series.
Okay. No. Okay. Yes,
You found that?
yeah. Is it the mandamus application?
Yes, the ruling, yes.
And the ruling, oh, okay, we attach it to our supplement. That's the B series.
Yes, I have it as A series, but fine. But the one in respect of Nana Akua Owusu Afriye.
Yes.
Have you seen the ruling?
Yes.
Please read the first paragraph of that ruling. It's in connection with whether or not you were heard.
So,
can you read it?
Yes. The application on the face of it is not different. And notwithstanding the submission of a friend of the court in the person of Godwin Kudu Ebiji Tamaklo to the effect that the winner of this constituency has been declared. And he proceeds, which no evidence is before the court, except an application yet to be moved.
Yes.
Yes.
So you made a submission.
No, the submission is to draw his attention of the pending joinder and the judicial review. And notwithstanding bringing to his notice. In fact, he described me as a friend. A friend of the court. At that point, I was not counsel for a party.
But you were not a party to the application. Perhaps that was why he decided to describe you as such. Yes.
No, my lord should see representation. You see that there is no record of me being a representative. See, counsel. Oh, my lord, just to draw his attention.
Anyway, we still have two other lawyers here. So
my lord,
you wind up.
My lord, on this basis, so my lord, this court has on many occasions upheld the fact that a person to be affected by an order or a decision should be heard. My lord, within this context, a failure to do that, my lord, will be a serious affront on to the rule of law, constitutional requirements and the right to head the other party. The Supreme Court, and my Lord, I conclude here. The Republic versus Court of Appeal, Anthony Tomford, ex-party Ghana Chartered Institution of Bankers, 2011. 2 SGLR, page 941. The Supreme Court, speaking through His Lordship Justice Aturuba, held that the terms of Article 296 are mandatory and obviously require the observance of the rules of natural justice, especially the ordinary rule involved. Or the anterior party rule has been elevated to constitutional pedestal, and this breach has constitutional consequence, my Lord, and said breaches void the act in question. My Lord, it's on this note that I draw the attention of this honorable court with respect to grant the application as prayed.
All right, thank you. Mr. Justin, counsel for the first.
Yes, my lords. My lords, we are opposed to this on our affidavit in opposition and the statement in support of that affidavit in opposition. My lords, except to add that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, a single one of them, has deposed to an affidavit in this court telling the court what injury they have suffered by General Decision 13, they're saying that Electoral Commission, go and perform and complete your constitutional duty. None.
Oh, you mean the...
Yes, my lords. There's nothing.
How about it?
My lord, the first applicant is not a party who has stood for election and for which he is claiming that he has an interest. He's an artificial person. These are individuals. The first go to parliament. It are individuals. Well, he said he has sponsored. Let the sponsorees, it's the sponsorees who go into parliament, not my lord. Of both number J4 dated 9th March 2016. Suit number J4/5/24. It's a judgment in which my Lord presiding and his brother Justice Badegbe delivered the ruling, and their ruling touched on the of Rule 1. Or that, my Lord, which is 4 Rule 5.1. And kind permission, if I may read. Of CI 47. No proceedings shall be defeated by reason or non-joint, and the court may in any proceedings determine the issue in dispute so far as of the person at proceedings. My Lord, even if we
that's
why I use the word even if we do that, the non-joinder will not defeat the proceedings. The court has a right to go left or right, and if it does, their course of action is one of appeal. So far, in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore certiorari should lie. Respectfully submitted. Thank you.
Oh, counsel.
Right.
But you argued Hawa Yakubu in your. You argued Hawa Yakubu.
Yes, my Lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No. My Lord, the order had an injunction placed, but in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder.
Doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder. But you can question it on other parties.
Yes, my Lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my Lord. And then also, one last thing, now that you have brought it up, my Lord, the application that they exhibited, that they had an application before the court, what they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my Lord will look at it as an application. My Lord, there is an application because of the way the numbering is managed. I'm not able to. It is an application. Let me give you.
Counsel, take your time.
Counsel. My Lord, it's an application file. Oh, my Lord. Well, my Lord, this is the application dated 16th. It was filed on the 16th of December 2024. My learned friend made reference to it. But in that particular matter, he hasn't brought the ruling of the court. There is a ruling of the court on that particular application. So, my Lord, to wrap up, none of the applicants before the court have made. Yes, thank you. I'm most grateful.
Okay. Thank you very much for saving our time.
I like the word mania.
Yes, Mr. Nimaku.
Valos, we are also opposed to this application. We filed a political position case on the 25th of December 2024. We rely on all the depositions made in the affidavit and the exhibits attached, and the authorities listed in the statement of case. My learned friend has hinged this application on a motion for joinder, which was not the docket of the court, which all parties took the action, were not served with the said application at the time when you were dealing with the mandamus application. My Lord, we submit. The application for joinder was indeed a non-starter. That is because, my Lord, there are specific rules dealing with mandamus application under CR 47. Specific rules. Joinder is not one of those. And my Lord, in Boifio, this is NTS for properties. Boifio, this is NTS for properties. 1996, 97. IGLR 531 at 533, this court held that the law was clear that where an enactment had prescribed a special procedure by which something was to be done, it was that procedure alone that was to be followed. My Lords, Order 55, Rule 5.2 has provided for the procedure by which notice of an appeal for judicial review can be communicated by the court to any affected party. That procedure is not joint application. I was from a court, the 4.5.2. The court may order that notice, and it's may order that notice of the application shall be served on any person not named as being directly affected by the application, if in its opinion, an opinion underlined, it is desirable that a person should be given notice. There is a rule, my Lord. There is a rule, not by joint application. And my Lord, this is a discretion which a court has to exercise. It's a discretion. It's a discretion. And if the court exercises discretion, whether rightfully or wrongfully, the aggrieved party, if so minded, cannot come by judicial review. The nation should arrive.
What is your authority for that?
My lords, if I may refer this honorable court to page 3 of my single case. Page 3. Republic versus Court of Appeal, Espanya Chachushikata, 2005-2006.
Oh, read the report.
Read the report. Very well.
If you have the report there.
Yes, yeah. The clear thinking of this court is that.
What page are you quoting?
Well, page 619. 619.
Yes.
The clear thinking of this court is that House Provincial Jurisdiction and Article 132 of the Constitution should be exercised only, in the word underlined, only in those manifestly plain and obvious cases obvious cases where there are patent errors of law on the face of the record, which errors either go to the jurisdiction or are so plain as to make the acquisition a complete nullity. My Lord, if I may even look, if you may
I get the point, but you see, you would agree that the ex parte Chachukikata case and the ground that was being discussed by Georgina Wood, JSC as she then was the ground of error of law. Let's pay attention to the fact that they also have a ground of failure to observe the odi alteram pattern. So, yes, if it comes to error of law, your point holds. But also address the area of the failure to observe the odi alteram pattern.
Yes.
You have argued it, but I think you should expatiate on it.
My Lord, we submit that a non-party to a suit cannot complain that his right to fair hearing has been breached. In this case, my Lord, I said Republic versus High Court, Accra. High Court, Accra. Ex parte, Danso, and others. MPP, EC, interested parties. 2015, 2016, 1 LGLR at page 760. 760. 1 Supreme Court of Ghana Law report at page 760. Holding 1. This court held in dismissing application for judicial review as follows. That in spite of the first ground by the applicant alleging breach of the right to fair hearing being a fundamental right that is available to parties to an action, this court is unable to extend its scope to persons who have not, on the record, yet become parties strictly so as to speak. My lords,
but there are several decisions. Republic versus colleague on a magistrate, ex parte Amponsa, which has been cited by Amenuvo. They said that as for certiorari, their public law reliefs, you don't have to be a party. And then we have.
This is about capacity. It is an order.
No, I just want to say that the general blanket statement may not be true because there are alternative authorities. If in this case you want to make a distinction, fine, but judicial review is a public law relief, a non-party can come for it. Ex parte Adavali and so many other cases. Yes, but make your point.
Yes, so the point we are making is very simple. The High Court only made an order directed at a public body to perform public function. To simply go and collate and declare a winner of a public elections. And my Lord, I believe that all of us here are interested in who is the winner or a loser in our elections. So that order, which the court made for the EC, the first to go and collate and declare who has won or who has lost, my Lord, it's a public function. It's a public function. How does that order to go and collate and declare the winner or a loser of our elections affect somebody injuriously?
Oh, look at your Exhibit 9. Look at your Exhibit 9. D9. Your Exhibit D9.
Yeah, my Lord, Exhibit D9.
Yeah, D9 is supposed to be, I don't know what I would call it, the collation sheet.
Yeah, it's a public document.
It's a collation sheet.
Which is a parliamentary election results summary sheet.
Yeah, now look at the last part. You know, that form has got the various candidates.
Yes.
And the marks or votes that is scored, right?
Yes.
Now look at the lower part, where provision is made for the candidates to sign or refuse to sign. Because the refusal to sign means that a candidate may disagree with the coalition and would want to raise an objection. That is considered and entertained by the Electoral Commission themselves. So how do you say that the order to collate doesn't affect third parties?
My lord, with all respect.
Because they have a right, even at the administrative level, to object.
Yes, my lord, under the CI 127.
Yes.
If a party decides not to participate in the process,
Yes.
it doesn't stop the EC from performing their function.
Yeah, but what we have here in your Exhibit D9 is the sheet which has only the MPP parliamentary candidate's name, his agent, and his signature. There is nothing about all the others. There is no reason why they did not sign. So the point I'm trying to make is that even the form of the Electoral Commission entertains the fact that in the coalition, the other contestants will have an interest.
My lord, with all respect to you, in the bench, this document, D9 that you are referring to, this becomes relevant when the results are gazetted and you want to challenge the result of an election petition. Petition, my lord, with respect. At the time when the court was making an order for Madam's application, this exercise I don't be effective. But now, personally,
I'm just trying to say that what the applicants are saying that they stood to be affected, and you are saying that they would not be affected. Electoral Commission is saying that they will be affected. That's why they have this form, which makes provision for them, for all the other candidates. So the Electoral Commission, Mr. Menubo, you can also comment on it. Because you didn't exhibit it, I didn't want to spring it on you, but it was exhibited by the 2nd to 7th interested parties.
Yes.
Yeah.
So my lord, I mean, this particular exhibit D6, 7, 8, and 9 is contained therein were not factored in.
Okay. All right.
At the time when the court making an order that proceed to go and do collation and declaration.
Okay. Agreed.
Mr.
Menubo, if you that's right. No, just one point. Mr. Menubo, if you have those exhibits, I think you should check them well, because D10, the form there is a bit different. So it will be of interest to you. You know, the D10, the form doesn't contain the portion for stating the reason why you will
yes,
not.
My Lord.
So it's of interest to you.
Yes, my Lord.
Okay, thank you. Yeah, Mr. Gary.
Yes, my Lord. So, my Lord, clearly, the point I'm making is that if there's public elections are being conducted in all polling centers, results declared in all polling centers, what is left is collation and declaration, summation of the various results in the various polling stations. Why should it be a problem, my Lord? Why should it be a problem? Why should should the EC not be allowed to do his work? So, my Lord, the point that we are making, granted without even admitting that The application for joinder, which we have said, my lord, is a non-starter, because the rules don't provide for joinder applications. If the judge has been aired, granted without admitting, the judge has been aired, the recourse of the petition of the applicant is appeal, not judicial review. And it's also should right, as you have to do it before you this morning. My lords, again, my little friend make a point about where's the rules book? About we not filing a statement of case. Thereby making the application not right for hearing, and the judge being biased. We refer my laws to Order 55, Rule 6, two, 3, of CI 47. That within 14 days after filing this application, the applicant shall file such copies of the case as the registrar shall determine, setting out fully arguments, relevant cases he wishes the court to consider. My lord, is the registrar. Now, if the applicant does not file a no case within a time stipulated under Sub 2, the registrar shall certify that fact to the court, which may dismiss the application for non-prosecution or make such other order as it may consider appropriate. There is nowhere, my lord, that the non-filing of the statement of case deprive the court of jurisdiction to detain the application that was before it, to the extent that the registrar or the court, which was supposed, if it was desired to do so, made no such order. In any event, my lord, the respondent, that is the EC, that was supposed to go and carry out its constitutional and statutory duties, did not put application. They took the view that yes, they wanted to go and do their work. And indeed, my lords, they have gone to do their work, declare the winner, declare the loser, and the matter is so close. So close.
If that were the law, the illegality will persist forever.
My lords,
so I'd like your other arguments, but as for foreclose,
my lords,
your other arguments you have answered substantive.
My lords,
My
lords, an order by a court to proceed to perform a constitutional and statutory function.
If it's set aside, that will be the consequences are clear in the authorities. Anyway,
with respect.
Yeah. Your other points I will take, but as for this one,
yes.
Yeah.
Further, my lords, it is not the applicants that were going to perform the said constitutional duty. Not the applicants. It's the first interested party. So granted, which I already indicated that the joint application was not funded by the rules. Granted, there will not have been a necessary party to the action. Granted, because the application was directed at a specific body, the EC, and no one else.
Now let me pick your mind on something the trial judge said in the ruling in respect of the application by Nana Equia Owusu Afriye. If one of your assistants can open to that. The ruling in respect of the application by Nana Equia Owusu. Yeah, B series. Now, if you can read the whole of paragraph 1 and it extends to the next page, read it and.
Paragraph 1.
Yes.
As B series. The application on the face of it is not different, notwithstanding the submission of a friend of the court in the person of Godwin Edugi Kujo Tamaklu, to the effect that the winner of this constituency has been declared, and which has no evidence, and which no evidence is before this court except an application yet to be moved. It is observation of this court that the respondent will not be affected if indeed it has been declared already.
Now you stop.
As it stands.
No, just now you stop there. You see, this conditional, if it has been declared already, where does it leave us? Because the applicants are contending that it was declared already. And then she is saying that if it has been declared already, then this ruling doesn't change. I'm finding it difficult.
Alos. Alos.
Yeah, you were there, so probably you.
Yes, Alos. The application might not friend far before you. If you look at all the exhibits which they have filed, my lord should realize, what is all this? My lord should realize that they have not, or they did not, what is this? They did not, no, our application, our affidavit, yes, they did not attach any parliamentary election results summary sheet to demonstrate that, in fact and indeed.
Oh, that, we hadn't reached that stage. Because
then direct me properly.
No, the point I'm making is that the judge is saying that if there had been a declaration already, then the person whom it was first declared for would not be affected by this ruling. But that is a very risky, slippery ground.
My lord, the bottom line is that, let's say, even there was even a declaration in court. But there was none in court. If the collation is done and you won, it will be confirmed that indeed you have won.
No. The judge said it will not affect her.
No.
Anyway, it is not your writing. It's because you were there, that's why I wanted you to react.
There is no way that if you win an election, and you have won an election, the results will change. If you have won, you have won. If you have lost, you have lost.
Anyway, that is the dispute. The dispute is whether the first person won or the second person. So that's the dispute. But I must be honest with you that the application before us, we are not in a position to resolve the factual dispute.
That is true.
As to whether the person who was first declared or the person who was second declared. We are not in a position to resolve that dispute. Ours is to look at the legality of the proceedings that resulted in the order for the Electoral Commission.
Yes.
Yeah, so wind up and then.
So my lord, in conclusion, I submit that another High Court judge was acting within a jurisdiction There is no error of law patent on the face of the record. Which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that the High Court judge exercise a discretion. If the applicants are agreed about the discretion so exercised by any High Court judge, their remedy lies in an appeal. And not this forum. My lords, we submit accordingly.
Thank you.
My lord, just a quick, okay. My lord, with your leave, just one point of law. My learned friend in his concluding statement says, our remedy lies in appeal. My lord, with the greatest respect, without being joined and being a party, we could not exercise the right to appeal.
I have authority to give him. I have authority to give him to go to an appeal. Is it there? And I will give it to him. Yes. 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 The authority is there. I'll give it to him.
The court will take a short break. All rise.
ما تعرض له محمود حسين تعرضنا له يعني وسنتعرض له. يعني هذه كلفة الصحافة. يعني هو قدم تضحية سبق أن قدمها زملاء له وسيقدمها زملاء له سواء في الجزيرة أو خارج الجزيرة. هذه ضريبة الصحافة.
كوني نشأت في أسرة كبيرة، ففكرة الأسرة الكبيرة دي مزاياها كتير جدا جدا. يعني دايما أنت ما لا تجده في شخص تجده في الآخر. أنا عندي 7 بنات. الابنة الكبرى آية دي خريجة، أولا أنا ما علمتش حد تعليم خاص، كله تعليم حكومي. هم مع نفسهم اجتهدوا. راحت مثلت جامعة القاهرة في شهر أغسطس 2015 وطلع بمشروعها رقم 3 على مستوى العالم. بنتي الثانية اسمها زهرة، الآن هي في 4 إعلام جامعة القاهرة، برضو بتجيب تقدير امتياز بشكل سنوي.
لما زرت بابا في السجن في شهر يونيو، ده كان شهر عيد ميلادي، رجعت من السجن بدول هدية عيد ميلادي. ده ألم ودي محفظة. على قد ما جمال وألوانهم مفرحة، على قد ما يعني ببص لهم بزعل وبفرح لأن هدية من والدي غاليين عليا. في نفس الوقت مصدرهم مكان حزين ما أحبش أفكر إن والدي موجود فيه.
نقف إلى جانب زميلنا محمود حسين وأسرته في هذه الفترة الصعبة بالنسبة لهم، وندعو له بإطلاق سراحه في أقرب وقت ممكن.
There have been many expressions of solidarity with Mahmoud Hussein under the same banner as the campaign to free me and my 3 colleagues. Journalism is not a crime.